We have two bills and several nominees on today's agenda. I'm also going to take a point of personal privilege this morning. I'll do that before Senator Feinstein speaks. Today we have a number of judicial nominees on the agenda, all of whom are on the agenda for the first time, so we will hold them over. The minority has requested that they be held over, so they will be. These would be Mark Bennett, Ninth Circuit, Nancy Brazel, District of Minnesota, also Eric Tostrad from Minnesota, and Robert Summerhays, West District, Louisiana. There are also two U.S. Marshals on today's agenda. We'll vote on them. By the way, we do have enough people here so that those that are being held over, as well as the Marrakesh Treaty implementation that's on the agenda for the first time, so we won't have to deal with those holdovers again. We will vote on two U.S. Marshals if we have a quorum. I want to thank Senators Feinstein, Corker, Menendez, Hatch, Harris, and Leahy for joining as co-sponsors on the Marrakesh Treaty. It's called the Marrakesh Treaty Implementation Act. It's supported by the National Federation of the Blind, by publishers, by libraries, the entire copyright community, and other public interest stakeholders. The bill has been a truly bipartisan effort, so obviously I want to applaud the ranking member and our co-sponsors for all of their hard work, and I look forward to taking it up when we get back after next week's recess. Today we will also consider the Special Counsel Independence and Integrity Act. This has been introduced by Graham, Coons, Tillis, and Booker. The intent of this bill, and if I'm wrong on this, the sponsors can correct me, is to ensure that special counsels appointed by the Justice Department are only removed for cause. The bill allows a special counsel a way to appeal his or her removal by the Attorney General to a panel of judges. The current bill is a result of months of negotiation between the bill's bipartisan sponsors, who introduced two versions of a special counsel bill in August. This committee held a hearing on those bills in September. At that hearing, we heard from constitutional scholars, some who considered the bill to be constitutional and others who felt it was unconstitutional. To some extent, the constitutionalities of these bills depend upon whether you think the Supreme Court decision in Morrison v. Olson is good law. Justice Scalia dissented in Morrison, and he's justifiably famous and influential, as we all remember, but its reasoning has not yet been adopted by the majority of the Supreme Court, and the majority opinion in Morrison v. Olson was cited with approval by Chief Justice Roberts as recently as 2010. If you believe in the principles of stare decisis, you have to admit that it's at least an open question as to whether Morrison v. Olson is good law and whether these bills are constitutional. You can try to predict what the Supreme Court will do, and they could overturn Morrison, but you might be wrong, and you wouldn't be the first to have made such a mistake. At the hearing, I told the sponsors that I would put their bill on the agenda for the full committee to consider if they could negotiate some compromise language. After they did a few weeks ago, the bill's here because I wanted to keep my commitment. The committee will debate and vote on the bill today. As I've stated before, I have constitutional concerns about this bill. I agree with Justice Scalia that the prosecution of crimes is an executive function, but I also think it's clear, and you folks know my reputation on this point, that Congress has an oversight role to play. Our constitutional system, premised as it is on the principle of separation of power, cannot function unless Congress exercises robust oversight over the executive branch. The Supreme Court has recognized as much, stating that Congress's oversight powers are broad, and that's a word from cases, and that, quote, a legislative body cannot legislate wisely or effectively in the absence of information respecting the conditions which the legislation is intended to affect or change, end of quote. Special counsel investigations directly involve the legislative work of Congress. Congress wrote the laws that any special counsel investigation is based on, and we can revise those laws. Congress appropriates the funds that make special counsel investigations possible, and Congress may use information gained from its oversight function to conduct hearings or to consider whether to resort to extreme remedies of impeachment. What's more, because special counsel investigations only occur where there is a conflict of interest within the executive branch, special counsel investigations are usually matters of great national concern. And Congress, by exercising its oversight powers, can help the American people to have confidence that these investigations are conducted efficiently and independently. To strengthen the oversight position of this bill, I've proposed text that has been included in the manager's amendment, which I hope the committee will support. This amendment is modeled after current statutory reporting requirements that require the executive branch to issue a report to Congress upon the removal of inspectors general. It also codifies certain Department of Justice regulations governing special counsel. My amendment is supported by the bipartisan sponsors of the bill and requires the Attorney General to provide a report to Congress when a special counsel is appointed or removed and when the investigation of the special counsel concludes. At least in the concluding report, the Attorney General must include information about decisions to expand or contract the scope of the investigation. My amendment is also narrowly tailored so as not to interfere with the progress of an ongoing investigation and to take into account national security and other concerns. Transparency and accountability is very much in the public's interest. The public's business ought to be public, except for maybe national security or privacy. Maybe a couple other things you can think of, but I mentioned those two for sure. The reporting requirements in my amendment will help Congress and the executive branch to do their jobs better. While my constitutional concerns remain, I believe this bill should be considered by the full Senate, and I think my amendment improves it. In addition, if other components of this bill are judged to be unconstitutional, I believe the reporting requirements in my amendment would survive. In some ways, today's vote will say a lot about how each of us view our responsibilities as a senator. We took an oath to protect and defend the Constitution of the United States, but we're neither judges or presidents. We're stewards of the legislative branch. The founders anticipated that we would wield the powers the Constitution affords us with great ambition so that we could effectively check the powers of the other branches. This bill certainly meets that requirement that we take in our oath to the Constitution. It's possible the bill goes too far, and I understand the position of those that have strong constitutional objections who will probably vote against this bill today. But at the very least, if my amendment is adopted, it will require the executive branch to give more information to Congress. And that will enable the Congress to do its job effectively, more effectively, in fact, and to safeguard the interests of the American people.